Hi, this is Sonia Kim. I'm the Marketing Manager at the Innovation and New Ventures Office at Northwestern University. In this INVO video, I'll cover the basics of patenting an invention. Your interaction with INVO doesn't end when you disclose your invention. As an inventor, it's important you understand the basics of the patenting process so you know what to expect next. Within the first couple of months of disclosing, several things will happen. First, you'll receive an email from INVO within several days of your disclosure. It will contain your submission date and a designated NU invention number. The NU number is important to include in your communications with INVO so that we can track your invention. Next, your invention is assigned to an invention manager, or IM, and will be evaluated by our team to determine if it's patentable. Lastly, INVO will make a decision whether to file a provisional patent with the U.S. Patent and Trademark Office, or the USPTO. The provisional is typically the first patent application that INVO will file on your behalf, but it does not mature into an issued patent. Our target turnaround for this decision is 60 days from when you disclose your invention. Occasionally, there are circumstances under which INVO may contact you. One is if insufficient information is provided in the disclosure. Or two, if they've come across other similar inventions and need help identifying differentiating factors. You may hear them use the terminology prior art. Prior art refers to previous ideas that have been patented or publicized in any form. Significant prior art may make patenting an invention more challenging. Or three, INVO may contact you if they're concerned about unfavorable responses from the USPTO. INVO anticipates, as usual, that the USPTO will aggressively seek any evidence or reason to bar it from issuing a patent. Based upon many years of collective experience, INVO and outside counsel may make recommendations to help increase the chances of getting a patent issued. Or they may recommend not filing based on the arguments that the USPTO has used historically. If INVO files a provisional patent application, the provisional is a placeholder and establishes the priority date for your invention. So why is establishing an early priority date important? It isn't so that the USPTO can start reviewing an invention earlier. Actually, the USPTO does not even review or evaluate provisional patent applications. They use this date to determine which inventor ought to receive an issued patent should an identical invention be submitted. Once the provisional is filed, there's almost no interaction with the USPTO during this year. With the new U.S. legislation, the America Invents Act, it's now a race to the USPTO. In general, the provisional patent application is not too time-consuming. There aren't strict rules for formatting or content, which enables INVO to file as quickly as possible. However, keep in mind that the application must have sufficient information. If it's filed prematurely with insufficient data, you risk losing your priority date. Once a provisional is filed, inventors have a year to continue to generate more data in support of their invention's viability to ensure a strong non-provisional patent. During this time, INVO will also conduct a more thorough due diligence study to assess the patentability and commercialization potential of the invention. With U.S. patent costs in the range of $25,000 to $35,000, INVO is not able to convert all provisional to non-provisional patent applications. However, Northwestern is highly likely to formalize the provisional application at the appropriate time if the chances of an issued patent are high, if there's a significant commercial potential, or if potential licensees are identified. To summarize, the provisional patent application sets the priority date for your invention. It's not evaluated by the USPTO and does not result in an issued patent. It expires unless it's converted to a non-provisional application within 1 year. The non-provisional is the formal filing of an invention with the USPTO and may mature into an issued patent. In addition to the requirement that an invention be new, useful, and non-obvious, it requires sufficient detail so that any person in the field can recreate the invention. If the patent application achieves this, it's said to be successfully enabled. The non-provisional captures invention details in a particular format, including an abstract, background, description, figures, claims, and summary. The claims are the most important component of the application, as they define the boundaries of patent protection. Attorneys break down the invention into one or more claims. By separating an invention into individual elements, they try to protect parts of the invention, even if the entire technology as a whole cannot be patented. INVO heavily relies on the disclosure to file the non-provisional, but further faculty engagement may be needed. If strong prior art is identified, the inventors are the most qualified to explain how their invention differs and provide the needed differences that can help the invention stand out against prior art. Ultimately, the level of faculty engagement will depend on the technology and the inventors involved. The IM will communicate expectations and requirements of the faculty. Once the non-provisional is filed, the 20-year patent life begins ticking. A USPTO examiner is assigned to the application and will communicate with INVO through a document called an office action. It may take anywhere from 12 months to over 3 years to receive the first office action. INVO has 90 days to respond to an office action, and only under extenuating circumstances INVO may file an extension. What should inventors expect with the office action? There are 3 types of responses to patent claims. It's common for many, if not all, invention claims to be rejected. The examiner cites arguments, typically in the form of prior art, against each claim. While it may be alarming, disappointing, or upsetting to get a number of your claims rejected, this is an expected step as INVO and the USPTO begin the negotiations process. The most common reasons for rejections are novelty and obviousness. For novelty, the examiner argues that a prior art contains all the aspects of the invention claim. And for obviousness, which is the most common type of rejection, the examiner argues that specific aspects of prior art can be combined to yield the invention claim. The latter reason for rejections is probably the most frustrating for our faculty. INVO understands that it can sometimes be inappropriately seen as a judgment on the inventor's scientific contributions. However, it's important to understand that obviousness has a legal definition for the USPTO, and with open communication and close interactions with INVO, many rejections can be successfully argued. Claims may also be objected or allowed. Objections are typically a matter of semantics in the form of a claim, and are usually quick fixes. Allowances by the USPTO are the best type of response in an office action. There's nothing more that needs to be amended for those particular claims. Our invention managers are scientists with PhDs and handle the majority of work directly with outside counsel and the USPTO. At times, their technical backgrounds don't align with technologies that come through INVO's doors. IMs are well aware of inventors' limited time and will minimize the inventor's involvement in the patent process as much as possible. However, the inventor's knowledge may help increase the chances of getting a patent issued. Inventors may help clarify and strategize a response to the examiner's rejections. This stresses how important it is that INVO have the correct contact information for the inventors and that faculty be available during this process. We will aim to provide about a month of advance notice for faculty to respond. There are a number of iterations between INVO and the USPTO before claims may become allowable. The goal is to get the broadest protection possible to prevent others from inventing around your patent. A patent may have less commercial value if only narrow claims are issued. INVO will be notified when and which claims have been successfully argued. These allowed claims will be covered by the issued patent. On average, getting a patent issued can take between 3 to 10 years. However, this process is unpredictable and relies on the timing of the USPTO. Unfortunately, there's a lot of hurry up and wait. During this time frame, as inventors continue to do research and discover, it's possible for inventors to improve upon their original invention that's been filed. It's important for inventors to notify INVO of these improvements so that we can work to protect them with additional filings called CIPs, or continuations in part. Building on inventions will help create a solid patent portfolio for an invention and improves its commercial value. Here's the timeline for an invention that successfully goes through the entire patenting process. Starting from the invention disclosure to INVO, the provisional and non-provisional filings, office actions, and issued patent. However, many inventions do not make it through the entire timeline, dropping off at different points. INVO will do its best to protect intellectual property that has the highest chance of being issued and being commercialized. As inventions are evaluated throughout its lifetime by INVO, on occasion, the commercial value or the potential of patentability changes and does not look as promising as before. In these instances, inventions may be released to the inventors or abandoned. If you have any questions, please contact INVO at invo@northwestern.edu. We hope you enjoyed our second video. Stay tuned for our third video, which will cover the licensing process. Thank you.